Good evening, friends. As we had promised and as we had put in our previous post, we are going to be talking about the Real Estate Regulation and Development Act of 2016, popularly called RERA. And the whole idea is to talk and discuss about a few myths which consumers have, which the builders have, and the idea is also to blast some myths. Now, this act actually was notified in and gazetted after being passed by both the Houses of Parliament in March of the previous year. But there were certain sections which were notified only on the 1st of May. So actually the time was given to the various state governments to get the act together, to set into position the housing regulator and so on and so forth. And the whole objective of the talk today is to really blast the myths which we otherwise cannot understand if one goes by the plain reading of the act, or sometimes the type of reading that you require is so very deep that those finer nuances cannot emerge. I happen to be serving in the Ministry of Housing and Urban Poverty Alleviation from August of 2013 for about 1.5 years, and incidentally my job as the Joint Secretary of the House was to take on the job of taking this enactment further down the line. To put things in perspective, at the time when this act was being cobbled up, you had the UPA government led by Sardar Manmohan Singh in position, and the minister in charge of HUPA, Housing and Urban Poverty Alleviation Ministry, as distinct from the Urban Development Ministry, was Madam Girja Vyas from Rajasthan. And of course, after the Modi government was sworn in the year May of that is 14, so we had Mr. Venkaiah Naidu taking over as the Minister of Housing as well as the Urban Development, which earlier was a separate ministry. So a lot of consultative processes, including consultation with stakeholders, builders' lobbies, consumer organizations, lawyers, more importantly, joint parliamentary committees, all those were taken up during the tenure that I was there before. Of course, I proceeded on promotion as Additional Secretary of the Government of India. Now, the whole argument of the builder lobby at the time when this method, this enactment was being talked about, was that if there is one sector which is over-regulated, which has too much of regulation, that is the real estate, housing, urban development sector, because you have to have so many clearances, right from certification of the land titles, to change of land use, to master plan issues, air safety norms, the FAR issues, compliance with the periphery laws, land control laws, fire issues, pollution, environmental clearances, that even under the ordinary set of circumstances, they argued that it was impossible for a builder, big or small, to get all the clearances. And the net result was that you had fly-by-night operators who were then working and setting up colonies and housing apartments without complying with either statutory provisions or any of the other legal permissions, oblique licenses that were required. So we had to have a kind of a consensus. On the other hand, the consumer organizations, which incidentally are very active, they were saying that this is one set of suppliers, the builders, the colonizers, who are beyond the control of anyone. They are just taking away and siphoning the money of the people, and therefore, this being the case, if there is a sector which needs to be regulated, then this is the real estate sector is the one which needs to be regulated. Of course, remember that land and housing are state issues, and therefore we needed resolutions from various state assemblies for the concurrent list to actually come into play, and certain entries in the concurrent list dealing with contracts, etc. were taken up, and that's how the parliamentary jurisdiction actually came up. Now, that being so, the Act went through various changes. Some people wanted an Act which was absolutely without any teeth, an Act which would create a regulator, but the regulator would not really have any teeth. And on the other side, you had people who wanted an enactment that would be very stringent, and you could actually put a promoter into the jail at the slightest non-compliance or default. And I do remember that when I first talked to our new minister, Mr. Venkaiah Naidu, after he assumed office in the month of May of 2014, I think his guideline was very clear. He said, regulation, yes; strangulation, no. And at the same time, there are various real estate national level organizations like Naradigo, Crede, and so on. And we had numerous discussions with them, including the real estate wing of the Confederation of Indian Industry, so on and so forth. And of course, various other ministries were also involved, not the least being the Ministry of Urban Development. So now the Act is in place, and things are rolling or have to start rolling. And therefore, we will address the myths that were created either during the legislative process or the myths which are still here regarding the Real Estate Regulation Act, popularly called RERA, which is now the law of the land, effective 1st of May. RERA is actually in its totality applicable throughout the country. Now, this being the case, we have to, beg your pardon, take myths one by one and see how we can address them. Now, the first myth was perpetuated and floated by the builder lobby, and that myth was, as I had outlined before, that there are already so many permissions and now you're adding one more permission. Now, this Act very clearly states that whatever permissions that you need to take, we are neither adding to those permissions nor taking them away. Change of land use, environmental issues, building plans, master plan, change of land use, whatever you have, let those be in place. What the housing regulator simply is going to do, what the real estate regulator is going to do is this. They say, please have all your permissions in place and then put it on to our website through the online process so that your registration with the housing regulator or the real estate regulator is complete. In other words, no new permission is required to be taken by the builder other than what is required under the law of the land. All that the Act says is that please have your permissions in place and then you register with the regulator. Now, this is very important. It is a process of registration, not a process of licensing or permission. So all that you do is put all your permissions, scan them through the online process. You have a login ID and you put the whole thing so that the public at large is aware that this is the set of permissions that you have at your disposal. And the law says that if the regulator is not coming out with any decision one way or the other within 30 days, then you have a deemed approval. In other words, once you have uploaded all that is required, which is pretty voluminous, no doubt about it, and nothing new, all those permissions you do require already, once you upload that, it is incumbent upon the regulator to say yes or no, and in the event the regulator is saying nothing for 30 days, the approval is automatically there. So no new permissions, no new licenses, but a process of registration with the housing regulator with a deemed approval clause being built in. So that is what the first point is, that it does not increase in that sense any compliance levels. All it requires you to put it in one place so that your registration is complete, and more importantly, since those documents are going to be in the public domain, then the people should be able to have a look at those documents in respect of your projects. The other thing was that the projects are going to be delayed. This was another myth which is being perpetuated or was being perpetuated. Now, under various laws already in place, you cannot start the development, obviously, unless you have a license to develop a colony, as in case of Punjab, or you have a building plan which has been sanctioned, and so on and so forth. So those restrictions regarding the beginning of the development works are already in place, and the RERA Act does not at all propose any new restriction. RERA Act says that please do start your development even without registration, we don't mind, as long as you're permitted by the local laws. RERA kicks in not with your development. RERA kicks in when you start involving the public money. So once your project is going to be marketed, whether it is a soft launch, internet marketing, so on and so forth, you're taking pre-booking, the definition is very, very broad. So please do the development, buy the land, start the construction of your colony if it is otherwise permitted by the state laws. But if you want to involve the public money, it is almost like the Security and Exchange Board of India. As long as the company is raising money from few private investors, these SEBI regulations don't come into play. But once you are bringing the public money in, then you need to have registration done. So therefore, there is no question of your projects being delayed. Of course, to the extent that you need the permissions in place before you involve the public money, that is something which is in public and consumer interest. If you don't have the resources, please don't play around with people's money without full permission that you have. So that really takes care of the whole myth that this is going to be, further delayed in the whole process. Then they are talking in terms of this whole real estate is going to become costlier because of the regulatory things. So no new cost is really being added. The registration fees, etc., are minimal. There are no rigorous standards being imposed, and therefore, in terms of the incremental addition to an apartment block, which is, say, housing 100 units, I think the fees all put together may not be even in the vicinity of 5 or 6 lakhs by way of government fees. So this is really, really the issue, and that is what we are trying to say, that the public money, and so we are trying to get those people on board to really have the permissions in place, and it is not going to get costlier because of the regulatory concerns. Now, the two myths which consumers have is that, hey, this is something which is going to now ensure me the quality of the product. Now I'm not going to get a second-rate product. And this is not something which has been talked about and discussed in public domain, though I have flagged the issue in my own humble way in various public forums. This Housing Regulator Act does not lay down any standards in terms of building. Of course, you have to be compliant with the structural safety and so on, which are the local laws. What is important is that this act does not say that thou shalt have marble flooring, or you will have ordinary cement flooring or chips flooring, or what is going to be the standard of the fittings of the electricity and so on and so forth. All that the Regulator Act is saying, that whatever you are going to put, those specifications should be there in your registration application and therefore in the public domain, which really means once you go to buy apples, you ought to know what type of apples you're going to get it. If you're going to buy a cloth, you better know it's a silk cloth or a cotton cloth or a linen cloth or a terracotta. The standards have to be determined by you. If you are going to put in gold plating, for God's sake, do it. If you are going to sell junk, put it. The law does not bar you from making and marketing mud houses if they are structurally safe. All that the Act is saying, whatever your specifications are, please put them in black and white. And once you do so, you stick to the same. This is regarding the standards. So therefore, the standards have to be laid down by the builder himself, and the consumer has a right to know that standards upfront, and then it is not up to the builder or the promoter to midway change those standards either for better or for worse. So therefore, per se, quality is not going to be ensured. What the Act is going to ensure is that whatever you promise, you deliver. If it is gold, sterling, please let it be so. If it is brass, if it is rusted iron, let it be so. But let people know what you are actually going to market. So this is very important. The other thing which generally the consumer organizations are harping about, and even some of the local officials have been saying, that now there is going to be an expeditious completion of projects. You won't have a scenario where a project which is once started will go on, forever. Now, this is fortunately or unfortunately, this was something which was discussed and debated a lot. It says that we are not going to lay down any time limit for completion of the project. Let the builder put that figure in the public domain. If you are going to start and give the possession within 3 years, say it is 3 years. If you say, no, well, in my case, it is going to be as much as 5 years, please put that. If you think it is 10 years, please do put that. In other words, it is incumbent upon the promoter to lay down whatever time limit he would for the purpose of the completion of the project. But once you have really put that thing in the public domain, you become bound contractually and under the new statute to follow that. Of course, for things beyond the control, there are certain provisions where the regulator can allow you to extend, but my understanding is that the regulator is going to use them very sparingly. So therefore, to summarize these twin points regarding the quality and speed: quality, no standards laid down. you please get what you deserve, what you promise, deliver that in the temporal time frame, whatever you promised, please deliver that. So that's one point. The other point, which was very, I wouldn't say viciously, but very vigorously debated with the builder lobby, was a condition that whenever any person, any consumer is giving by way of an installments, 70% of that would go to a separate account to be maintained by the builder, by the promoter, which is specific to the particular project. Now, what was happening was that sometimes there is a project A, a tower A in Mohali, you're gathering money for that, that is what you advertise for that. The company is the same, it's just one legal entity, and you have something coming out in Kharad. So what you do is siphon the money of the Mohali project for the Kharad project, of the Gurgaon project for the Noida project, and so on and so forth. All those is now barred by the Act, but the account has to be separate, maintained by the builder himself. So earlier the builders were saying there's going to be official control, it is an escrow account, and once it is an escrow account, some official person is going to sign, and we are going to get into different, Mr. Sharma's problem, different states framing their own rules. I'll come to that and address it at the end. But the point which I'm trying to make is that these points kind of, we have to see that we are able to leave it with the beg your pardon for this thing and small interruption, and so these are the so 70% money, what we are trying to say is that you please put that money to use where you are going to, you've promised. You can't siphon money from one project to the other. People wanted flexibility, so on and so forth. No, that is not going to be possible. At the same time, there is no Inspector Raj being injected into the builders. The money has to be operated and to be with the person himself. Then the other thing which was being said, that it is totally one-sided. In other words, you created a lot of rights for the consumers and all the obligations for the builder, and therefore you are really making the builder a hostage to a person who could be a contumacious litigant and would literally be blackmailing the builder. Now, that is not the case. If you read, I wouldn't like to get into the nitty-gritty of the statutory provisions, but if you see section 19, there are number of obligations which the consumer too has, but the cardinal point is that once you sign an agreement, a contract for the purpose of buying a plot, a flat, an apartment or unit by whatever description you may call it, then you have to stick it, and penalties which kick in if the consumer himself is also not able to discharge those. Of course, relatively speaking, there are more obligations for the builder, but essentially the obligations are what he promised. It is not as if some arbitrary obligations are being cast upon the builder, which makes compliance so much more difficult. Another thing which was being discussed was as to whether, what happens to the cases which are going in the consumer forums, and why do you want to have another forum, and so on and so forth. Now, first of all, let's understand that the regulator, the housing regulator, which the state governments will set up, and I think it is going to be headed by a retired judge of the High Court, so a judicial connotation to the housing regulator who does the registration of the projects. It's not going to be a bureaucratic body, so that generally we say Babudam is coming into the housing sector, and there is a nexus and so on and so forth. So welcome. Premjit Lal was my director in the Ministry of Housing and Urban Poverty Alleviation, and we worked very closely together for this enactment, and of course he's also in a different position now. Premjit, thanks for joining and thanks for all the support, and also of Nagendra, which we work together for the success of this particular project. So what I was talking about then was the obligation and the consumer issues. The consumer issues were, you have consumer courts right from the district courts, and generally the pecuniary jurisdiction is that big cases go to the state commission or the national commission, and those are in any case flooded with a lot of litigation. Malini Shankar, our batchmate from Maharashtra, Director General Shipping, recently impaneled as Secretary, Government of India. Congrats, Malini, and welcome to this live telecast. Harpreet, again, former Additional Advocate General, very fine legal mind. So we're talking about the Real Estate Regulation Act. So now you have adjudicating officer. You can't expect a regulatory authority to get into individual consumer issues. The housing regulator is dealing with essentially the bigger issues of the project and problems relating to the compliance or non-compliance of the project as such. Now, what the Act envisages is adjudicating officer who are going to be in the rank of a district judge, retired, that is almost session judge, even a serving one perhaps, who would take the consumer issues. And there are two distinct portions which the consumer needs to remember, is that if there is inferior service, of course, you get the compensation and damages. You know, they're two different things, compensation and damages. So one is that you paid something, you got a product which is inferior, so therefore there would be compensation to that extent. And damages is a kind of a penal element. So these adjudicating officers have to be judicial officers who would take issues that are essentially individual in nature. And the pending cases, you are at liberty to withdraw those with the permission of the national or the state commissions and transfer them to the adjudicating officers. Of course, a very rigorous time frame has been laid down for the decisions to come in. We got a friend, Vikramjit Kaushik, doing real estate business in Mohali, and he would be also watching. Thanks for joining, because they would have a very specific perspective on how the things are going to be. Another thing which I would like to say and tell our friends is that if you think that the pending projects are not going to come under this enactment, I was very particular, and I remember Premjit and I having huge discussion therein. Any project which is on existence on the 1st of May 2017 and which does not have a completion or occupancy certificate also needs to be registered with the regulator. So therefore, it is not only the projects which would be conceived and take off afterwards, but the pending projects which may have been sold out, that's not the point. You may have completed the projects, fine, but do you have a completion certificate from the licensing authority, the competent authority? If not, you have to, under the law, register yourself with the regulator. So the idea of adjudicating officers then is to really have people to give you quick, fast-track compensation, and therefore, in that eventuality, compensate you and provide for damages. And there is a single appellate tribunal. I may be open to correction because I have not gone through the fine print recently. The orders of the adjudicating officer as well as the authority are both appealable to this state level appellate tribunal. so that both the consumer as well as the promoter have a remedy there. And thereafter, of course, you have the jurisdiction of the High Court, which is always there. Now, what are the powers? Is it a watchdog? Is it a draconian statutory instrument which has been unleashed by the law to tame the builder lobby and the land mafia and so on? These are the words which we generally hear when we talk about the real estate. Generally, the act is pretty benign. And if you see, most of the time you're talking in terms of civil penalties, which are not really conviction, which is not really an offense under the law. The whole idea is to make the builder compliant with whatever he'd originally committed and whatever he had originally promised. So if there is a default, there are compensation and damages kicking up. If there are contraventions, there are penalties which are perhaps sometimes on per day basis or on per month basis. Of course, there's an upper cap. But ultimately, a quasi-judicial tribunal, whether in nature of a housing regulator or whether in terms of the adjudicating officer, now ultimately, if its decisions are not, Rajiv Mishra ji, welcome. He's currently the Joint Secretary Housing in the Ministry of Hoopa, or has been promoted as Addition Secretary, I guess now, who was the man in position as Joint Secretary Housing when this enactment actually got the seal of the President of India and became the law of the land. Thanks, sir, for joining. And therefore, the whole objective is not to put the builder in prison. The objective of the law is to make him compliant and deliver what he had promised. And of course, in the ultimate eventuality where you are not then complying with the law of the land, then surely there are offenses, and those offenses are not going to be tried by the regulator or the tribunal themselves. There are judicial courts under which the normal law of the land in terms of burden of proof and criminal prosecution would then kick in. And even then, finally, you have all the offenses under the Act are compoundable. So the whole idea is that if those acts of omission and commission, ultimately you are willing to rectify the defects, pay the penalties, pay the compensation, then it is not the intention of the legislature or the parliament to put you behind bars or to take the builder friends to the court of law. So this is really the essence of the whole thing. And what needs now to be done is that these authorities must be set up. And as our friend had observed, CP had observed, that rules have to be framed by the state government. And draft rules have been circulated by the Government of India. And generally it's going to be just a fill-in-the-blank type of a thing, and most of the state governments have already begun the process to do it. For the union territories, the Government of India has already notified the rules. And for the remaining states, it has to be done. And one of the additionalities which I had added was that, these tribunals do take time to be constituted. And these tribunals do take some time to come into place. So I think there is an interregnum in which the principal secretary of the concerned department, whether it is housing and urban development, town and country planning, or whatever, those principal secretaries act as regulators in the interregnum, but there is only a small space of 6 months or so in which they can do so, because the idea is not to perpetuate a bureaucratic setup to be looking into the registration of the whole real estate sector. So this is how the Act is going to really pan out. It is a very fine balancing exercise which balances the interests of all the stakeholders. And when I say all the stakeholders, I don't just mean the builders and the promoters and the consumers. There is also something called a town planning. You want town planning norms to be met in terms of roads, open spaces, schools, etc. So those would be met. You can't have too liberal norms so that the saleable areas, 80% you create an urban slum. It can't be too lax so that the project itself becomes unviable or the property prices really go up. So it creates a balance between the two, all the stakeholders. 2 points which I would like to add, and these are very important, and I think I should have outlined that before. The word allotee. The question is, if you bought a flat, all right, you have various statutory rights as well as obligations under that in this act. What happens if you've purchased a flat or a letter of allotment in the secondary market? You're stepping into the shoes of the first allottee. Do you have the same rights and obligations? We have made it very clear. The definition in section 2D very clearly states that a person who also purchases, the transferee also inherits the same rights and obligations. But we have excluded, the act specifically excludes the tenant from raising those issues. In other words, the builder has to talk to the allottee, the person who's actually purchased. If there are issues between the tenant and the landlord, those are to be tackled separately, and you cannot agitate them within the framework of this act. The final point before I close, after taking a few questions, if there are any, is regarding the registration of the real estate agents. Now, real estate agents, this was a profession which was not being regulated. Of course, in Punjab, under the Punjab Apartment PAPRA, Punjab Apartment Property Regulation Act, this type of registration is there, and most of the estate agents are registered. So these gentlemen would also require registration. Very simple norms are there, so that at least when you go to a registered salesperson, an estate agent, you know that he has some semblance of qualifications and he's just not a fly-by-the-night operator who will pocket his commission and walk out. So if there are any questions, we would love to answer. I've been meaning to talk to our friends on this subject since the 1st of May, but prior engagements elsewhere have really precluded me. So I thank you all for joining, and if there are any questions right now, I would try to answer them to the best of my knowledge and ability. Of course, you can always inbox me and I would try and answer those. But I can say that I would view this enactment with a lot of optimism, much more than cautious optimism, but to expect this to be a kind of solution for all the ills that ail the system of real estate, that is not going to be the case. There are issues of undervaluation and so on and so forth, which is a separate subject altogether. But in essence, this is an enactment which balances the interests of the consumer as well as the builder and binds down, pins down the the promoter to deliver what he promised, and should he not do so, compensation and penalty proceedings and damages would come in. And in the ultimate and the contumacious, obdurate default, you would have what is called the prosecution being launched. So thank you all for joining. I think it's been very educative for me also, and I particularly thank our colleagues and former colleagues from the Ministry of Housing and Urban Poverty Alleviation, who really worked very hard. It is not simple steering such a legislation through the process of the Parliament, and I do hope that the consumers at large and in this whole process of Prime Minister's program for housing for all, this enactment is going to play a very important role. So thank you very much. If there are any questions right now, I'd be sticking around for a couple of minutes. After that, we can then say bye for now and to meet later on a different forum under a different set of circumstances. Thank you, Sharma Sir, for some of the very incisive insights, and thanks for joining and sticking along in this little telecast of ours, if I may use the word. Thank you all. So if there are no questions, let's break. Have a nice evening ahead. Enjoy your Saturday, and bye for now. Thank you.